Welcome back. Today we're stepping into the world of international law, where treaties, global organizations, and legal principles shape how countries interact. Whether it's human rights, trade, or peace agreements, international law is everywhere. Let's dive in and explore how it works and how we can talk about it in professional legal English. Here's what we're going to focus on in this lesson. We'll start with vocabulary that lawyers use when talking about international law. Things like treaties, conventions, and legal bodies. Then we'll look at how grammar fits into this. You'll see how the passive voice and the present perfect are used in real legal contexts. And finally, we'll bring it all together by talking about the role of international institutions like the Inter-American Court of Human Rights, the United Nations, or the International Criminal Court, and how they operate under international law. Let's get started. When you hear the term international law, what ideas come to mind? Perhaps you think of global organizations like the United Nations, or important legal concepts like human rights and treaties. You might also associate it with places like The Hague, or with international courts that handle war crimes and cross-border disputes. Let's look at a few example sentences. International law is important because it helps countries resolve disputes and promote global cooperation. One example of international law is the Geneva Conventions, which sets rules for humanitarian treatment in war. These are the kind of ideas and language we'll explore in today's lesson, which is very relevant today. Let's start with the word jurisdiction. In legal terms, jurisdiction means the official power to make legal decisions or judgments. Think of it as asking, does this court or authority have the right to decide the case? Here's a common example. The court does not have jurisdiction over foreign nationals. You'll hear this word all the time in international law, especially in cross-border disputes or when determining which court has the right to hear a case. Next, we have sovereignty. Sovereignty means that a country has the full right to govern itself without interference from other nations. This concept is at the heart of international law and often creates tension when outside forces try to intervene. For example, national sovereignty is a key principle in international relations. International agreements must always respect state sovereignty, or they risk being rejected. Now, let's look at protocol. In legal terms, a protocol is not just formal behavior. It refers to a detailed set of rules or procedures, often attached to a larger treaty. It can update, clarify, or expand on the original agreement. The Kyoto Protocol added specific commitments to the original climate treaty. So when you hear about protocol in international law, think of it as a legal add-on to a treaty with real obligations. For example, like the protocol for the 1951 Refugee Convention. Now, let's talk about customary law. This type of law isn't written in a single document. It evolves over time through consistent behavior by states. When countries regularly follow certain practices and believe they are legally required to, those practices can become customary international law. Customary law develops over time through consistent practice and acceptance. Many important principles like diplomatic immunity started as customary law. Finally, we have sanctions, very relevant for countries, for example, like Cuba, Venezuela, Iran. In international law, sanctions are penalties, often economic, used to pressure a country to change its behavior. They can include freezing assets, banning trade, or limiting diplomatic contact. For example, the UN imposed sanctions for violations of international law. Sanctions are powerful tools, but they can also be controversial, especially when they impact civilians. Let's begin with convention. In international law, a convention is a formal, multilateral agreement, usually created and adopted by multiple countries. It often sets out broad principles or standards that countries agree to follow. The Geneva Conventions set rules for the treatment of civilians and prisoners of war. Conventions are major tools in shaping international cooperation on human rights, war, climate, and more. Next, we have binding. When a law or agreement is binding, it means it's not optional. It must be followed. In international law, treaties can be binding if countries sign and ratify them. The treaty is legally binding on all signatory states. This word is important because not all agreements have the same level of obligation. Some are just guidelines, and others are binding and enforceable, and some are in the middle, like the Declaration of Cartagena in refugee law. Now, let's look at international body. This refers to any global or regional organization made up of multiple countries. These bodies often create rules, resolve disputes, or coordinate action on global issues. The World Trade Organization is an international body that oversees trade rules. Other examples include the United Nations, the International Criminal Court, the World Health Organization, and more. These institutions play a major role in international cooperation. Let's talk about ratified. When a country signs a treaty, that's only the first step. Ratification means the country has officially approved the agreement, often through its national government or legislature. The agreement was ratified by over 100 countries. Without ratification, a treaty may not have legal force within a country. That's why this step is crucial for turning promises into obligations. Finally, let's review treaty. A treaty is a formal, written agreement between two or more countries. It's legally binding once signed and ratified, and it can cover everything from peace and security to trade and environmental protection. For example, the two countries signed a peace treaty after years of conflict. Treaties are the foundation of international law. They create rules that countries agree to follow. Let's try something different. Instead of definitions, I'm going to give you some short stories from the real world of international law. Each one includes a real legal moment. You listen and try to guess the key legal term from our word bank. So we have words like ratified, protocol, international body, sanctions, and jurisdiction. Listen to this story now. In 2021, after months of public debate, the United States Senate held a vote on a new international climate deal. The president had already signed it, but for it to take legal effect, Congress needed to approve it. After hours of speeches, they voted yes. That final step made the agreement official. What's the legal word for this process? Exactly, ratified. When a country gives formal legal approval to a treaty or agreement. Let's look at the next one. Conflict had broken out between two neighboring countries. Tensions were rising, and both sides refused to speak. That's when the United Nations stepped in. They helped mediate talks, bring in experts, and monitor a ceasefire agreement. They weren't a court, they didn't make the law, but they helped make peace possible. What kind of legal organization is this? Exactly. International body, a global or regional organization that supports cooperation and legal solutions. Now let's go to another one. Two countries signed a treaty to make cross-border trade easier. But months later, confusion broke out. How exactly do we verify shipments? Who does the inspections? So they wrote an extra document, a step-by-step set of procedures added to the original treaty. It explained how the agreement would actually work in practice. Now, what's the legal word for this kind of document? Perfect. Protocol, which is an official set of rules or procedures attached to a treaty. Now let's go to the next one. In a high-profile trial, a family wanted justice after a crime committed during a vacation overseas. They filed the case in their home country, but the court said, "We're sorry. This crime happened abroad, in another country. We don't have the legal power to hear this case." What legal concept explains this decision? Exactly. Jurisdiction, the legal authority to hear and decide a case. For example, the European Court of Human Rights would never hear a case about human rights violations in Guatemala, and the Inter-American Court for Human Rights would never hear a case about human rights violations in China, for example. Let's go to the next one. Country continued to ignore global human rights standards, silencing journalists and attacking protesters. It's happening in a lot of places now. In response, several nations acted together. They froze that country's assets, they banned trade and travel, and the goal of this was to pressure them to change. What do we call these legal penalties? Sanctions. That's what they are. Sanctions are penalties used to influence or punish a country's actions. Now, two countries had been at war for nearly a decade. Then, through help of mediators, they met at a neutral location. After days of negotiation, both sides signed a formal agreement promising to end hostilities, respect borders, and protect civilians. This agreement was signed by both heads of states and carried legal weight between nations. What do we call this kind of signed international agreement? Exactly, a treaty, which is a formal signed agreement between states that carries legal force. During a global conflict, reports surfaced that prisoners of war were being mistreated. That's when an international legal document came into play. One that outlines clear rules about how to treat soldiers, civilians, and the wounded during wartime. It wasn't just a single country's law, it was an agreement accepted by many nations, many countries. What's the name for this type of legal document? Exactly, a convention, which is a multilateral agreement that sets shared legal standards, often on human rights or humanitarian issues. A group of international companies signs a global trade deal to operate freely across borders. They agree on shipping rules, tariffs, tax benefits, and uniform standards. But one country says we need to protect our domestic industries, our industries in country. We won't accept foreign control over our regulations. That country decides not to participate in the agreement. Why? Because it has the right to make its own decisions about trade, law, and economic policy, even if others disagree. What's the term for a nation's power to govern itself without outside interference? Perfect. Sovereignty, which is the full legal authority of a country to control its own territory, laws, and policies. An international court ruled that a corporation had violated environmental law in a developing country. The court's decision stated that compensation must be paid within 90 days. The company tried to delay, but the court made it clear this was not a suggestion, it was a legal obligation. What's the term for something that must be followed by law? Binding. Binding is a legal term meaning that an agreement, decision, or rule must be followed. Last story. A new state joins the global community, but it hasn't signed any international human treaties yet. Still, it agrees not to torture prisoners. It treats foreign diplomats with respect. It doesn't invade its neighbors. Why? because these rules are so widely followed that they apply to all states, even without a formal agreement. What's the term for unwritten international rules that become legally binding through widespread state practice and acceptance? Customary law, which are rules that arise from consistent state practice and a belief that the practice is legally required, also known as opinio juris, even without a treaty. When people hear international law, it can sound distant or abstract, but actually, it affects real countries in very real ways. Let's take Costa Rica as an example. One major treaty that shaped policy here in Costa Rica is the Escazú Agreement, which is focused on environmental protection and public access to information. Costa Rica was one of the first countries to sign it, but it wasn't until 2022 that it was officially ratified by the legislature. That made it binding, which means it's not just words on paper anymore, it's something that the country must follow by law. Of course, for treaties like this to work, there needs to be a structure, a clear protocol about how the rules are implemented, and who has jurisdiction when conflicts arise. And while some rules come from written agreement, others are based on customary law, long-standing practices between countries that are followed even without a formal document. If countries ignore these responsibilities, they can face sanctions, economic or political penalties from the global community. So even though Costa Rica is small, it plays a big part in international cooperation, especially as the home of an important international body, the Inter-American Court of Human Rights, right here in San Jose, Costa Rica. Let's talk about one of the most common grammar features in legal English, the passive voice. We use it when we care more about what happened than who did it. Take this example. The contract was reviewed by the legal team. The focus here is the review, not necessarily who reviewed it. Or, the suspect was arrested without incident. That sentence feels formal, neutral, perfect for legal writing. Now, look at this. New regulations have been implemented worldwide. We don't even need to say who implemented them, and that's the point. In legal English, the passive voice keeps things objective, professional, and non-confrontational, and sometimes it's useful when no one wants to point fingers. Let's practice using the passive voice, and I'll explain why each version works better in legal English. First one, lawyers draft binding agreements. In passive, its binding agreements are drafted by lawyers. Here, we're not focused on who is doing the drafting. The emphasis is on the agreements themselves, and that's what matters in a legal document. Second, the government signs international treaties. In passive, its international treaties are signed by the government. This version feels more formal and objective. It highlights the action, the signing, not the actor. Last one, judges review case files carefully. In the passive, it would be case files are carefully reviewed by judges. See how this version centers the files and the review process, not the people involved. It sounds more neutral and professional, which is often the goal in legal writing. So, why do legal professionals use the passive voice so often? Well, it helps you focus on the action, not the person behind it. It creates a more objective, formal tone, perfect for writing laws, rulings, or legal letters. And sometimes you just don't want to assign blame. Saying the law was violated is a lot safer than naming names too early. That's why the passive voice shows up everywhere in legal English, especially in contracts, judgments, and international agreements. Let's talk about how we describe change over time in international law, and for that, we use the present perfect. Here's the structure: has or have, plus the past participle. Why use it? Because it connects the past to the present, and that's exactly what international law does. For example, the treaty has been ratified by 85 countries. That action started in the past, but it's still important right now. Or, human rights law has evolved since the 1940s. We're not talking about one moment, we're talking about a process of change that's still happening. We use this when you want to show that legal frameworks, agreements, or institutions aren't static. They grow, they adapt, and they develop over time. Let's say a country's in negotiations, maybe on trade or climate policy, and it's willing to make some compromises, but then it says, we will not agree to any deal that weakens our environmental protections. That's what we call drawing a line in the sand. It means setting a firm boundary. In legal or diplomatic terms, it's often about protecting values or non-negotiable principles. This idiom signals beyond this point, we won't move, we won't budge. Sometimes two parties, or even two countries, are negotiating from opposite sides, but they still want to work together. Maybe they care about regional security or human rights. That shared goal is called common ground. For example, although they disagreed on many issues, they found common ground in protecting indigenous rights. In law and diplomacy, finding common ground is key to reaching a fair agreement. When something has never been done before, and suddenly it is, we say it breaks new ground. International law is full of these moments. Think about the creation of the International Criminal Court that broke new ground in holding world leaders accountable. This idiom is often used when laws, rulings, or agreements move into uncharted territory. It's about leadership, bold action, in setting a legal or diplomatic precedent. In law, nothing counts until it's written down. That's why we say something is in black and white. It's official, formal, and cannot be misunderstood. For example, the treaty was finally put in black and white, confirming the new border agreement. This idiom emphasizes that what's written has legal weight. In legal English, it's a reminder that clear documentation is everything. All right, guys, now let's review some key terms you'll hear a lot in international law. First up, advisory opinion. This is legal advice from a court, and it's important to know it's usually not legally binding, so it's more like a recommendation. Next, the judicial branch. That's the part of a government or organization that interprets the law and makes legal decisions. Then we have territorial disputes. That's when countries argue over land or borders. And finally, jurisdiction. We'd cover that one. Again, this means the legal power to make decisions or judgments. Now, where do all these fit in real life? Let's give you an example. Well, that's the role of the International Court of Justice, the ICJ. The ICJ is based in The Hague, in the Netherlands. Think of it as the world's legal referee for countries' disputes. It helps settle conflicts like territorial disputes or maritime issues and gives advisory opinions. Those legal recommendations I mentioned. While the ICJ's decisions are respected by most countries, it doesn't always have strong enforcement powers, but its main job is to promote peaceful, fair legal solutions worldwide. So, which one of these words do you think describes the ICJ's work best? Well, drop your thoughts in the comments. It'll be interesting. I'd love to hear from you. Now, let's do a role play. Imagine you're at a border crossing as an immigration lawyer. An asylum seeker wants to enter, but the immigration police are hesitant. They think the person can be turned away without a proper claim. As a human rights lawyer, immigration lawyer, your job is to explain why the law protects this person's right to seek asylum and receive due process, even if the situation feels uncertain. Key things to keep in mind: right to seek asylum under international law. Authorities must allow a filing of a claim and a fair process. The state must protect against return to harm. And the state also must balance security with respect for human rights. So here's what you could say to the immigration official. Officer, under international law, including the 1951 Refugee Convention and international human rights law, anyone who expresses a fear of persecution has the right to make an asylum claim. It's not just a formality, it's a fundamental human right. Denying entry without allowing the person to file a claim could violate this right and lead to serious consequences, including returning someone to danger. Even if you're unsure about the claim's validity at this point, the law requires a fair process to assess it properly. This means the asylum seeker must be allowed to enter the country, present their case, and have it reviewed by the appropriate authority. Your role is crucial, but it must be balanced with respect for legal protections and human dignity. If you refuse entry outright, it risks violating both international and domestic legal obligations, which can have legal consequences for the authorities involved. Great work today. Let's quickly review what we practice. First, we learned key vocabulary like treaty, convention, and ratified, essential words when discussing international law. We also looked at the passive voice, which helps us focus on actions and keeps our language formal, neutral, and clear. Then we practiced the present perfect tense, perfect for talking about legal developments and changes over time. Finally, we practice speaking about international law and global organizations so you can confidently discuss these important topics. Keep practicing these skills. They'll really boost your legal English and help you communicate professionally. Thank you.